Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Doreen.
And I'm Mandana Niknejad.
Welcome to Hull on the States. You're listening to episode number 723. Today we're going to be discussing the hot button subject that there's been much ado on, which is the proposed changes to the rules of civil procedure here in Ontario. Now, Mandana, I know that you've been deputized at our firm to be sort of like our leader on the subject, just because there's been, it's a big proposal. It is going to very fundamentally change the litigation process, even though it is not really meant to change any like substantive rights. But it is all about how are people supposed to like pursue their claims in court, as well as like defend the claims against them, and how are we ever sort of like gonna get to like the final trial. Do you want to maybe like give us a little bit of background, Mandana?
Yes, sure. Thanks, Doreen. So as Doreen mentioned, there's going to be major changes to the rules of civil procedure. I'm going to start by giving a quick background of these changes. The Civil Rules Review project was launched in January of 2024. The mandate of this review was to modernize and streamline the civil justice system by improving procedural efficiency, reducing delays, costs, enhancing access to justice, and leveraging technology to support these goals. This review is being carried out in 3 phases. We are now past the phase 1 and 2, which involves scoping and research and policy proposals. In April of 2025, the working group released a consultation paper that contained the policy proposals, and the public was invited to provide feedback on it until June 16th of this year. Right now, we are in phase 3, which is the approval and implementation stage. And this phase will continue until December 2025. And during this period, final proposals and draft regulations will be prepared and filed, and the changes are actually expected to come into force as early as 2026. Now I'm going to quickly review some of these main changes, and maybe we will dive more deeply into one after that. So the key proposed changes according to this consultation paper are, first of all, introduction of pre-litigation protocols for certain type of cases, such as disputes over the validity of testamentary documents that we deal with. So like certain requirements should be met before commencing litigation for these cases. And then there's going to be a single point of entry for commencing all types of actions and applications using an online fillable form. There's going to be a new duty to cooperate for parties and their counsels throughout the litigation process. As Doreen mentioned, there's going to be a fixed litigation timeline that is being proposed, and according to that, all cases must reach a substantive hearing within 2 years of the commencement of the pleadings. As a result, adjournments will be very restricted and granted in exceptional circumstances. Service rules are being changed, and they're going to be more flexible. For example, service by email will be permitted. The basic limitation period will be extended from 2 to 3 years. There will be a lot of restrictions on use of motions. And for example, for procedural matters, there's going to be no motions, and they should be addressed at direction conferences. And also parties cannot inherently bring any contested motions anymore. Mediation, which is mandatory in certain jurisdictions in Ontario, will be mandatory province-wide. And there's going to be a new system called Paper Record Plus process for summary hearings. expert evidence will undergo changes, use of expert evidence. For example, each party will be limited to use only one expert per issue. And in some cases, the parties will have to retain joint experts. But I think one of the most debated reforms so far is the introduction of the upfront evidence model for discoveries, which will replace the current system. May explain it a little bit, and then switch it to you to see what you think about it, Doreen. So under this new model, the oral examinations for discovery will be fully eliminated, and the parties will be required to serve all the documents that they refer to in their pleadings at the time that they are serving their pleadings on the other party. All the documents that are referenced and not publicly available. And after this stage of disclosure is done, there will be another part of the disclosure that should be done within 1 year of the closing of the pleadings, and during which the parties must provide full disclosure of all their documents, affidavit of documents, sworn witness statements, their proposed timeline for exchanging expert reports. But I think to kind of strike a balance, the standard of production will shift from the current relevance-based model to a modified reliance-based model, which means parties must disclose all documents they intend to rely on, as well as any known adverse documents. And after this stage of disclosure, then the parties can request the other party for further disclosure, but in very limited cases, they have to use a red fern schedule, which is something that is currently used in arbitration, and will be limited to requesting the specific requests for relevant and material documents only. And there will be room for a limited number of written interrogatories afterward, but again, very limited in scope and number. So that was my brief summary of the changes. And
Yeah. Wow. I'm so impressed that you were able to cover so much, even in just like, I don't know, like, was that 3 minutes, 4 minutes, 5 minutes? I don't know. But I think that really gives like our listener a sense of like just how wide sweeping and detailed all of these changes are. Like somebody really looked at the litigation process and model in Ontario from nose to tail, so to speak, right? Like from the very beginning on how someone like starts a lawsuit and what they have to do and like the surface requirements they have to fulfill, all the way to like, okay, when are you actually ready to go into that courtroom and argue something that is contested? Like every step of the way, what do we have to do? And, you know, everything that you've said is like so radical to me because it really is, if it is sort of like what we're seeing now from like the phase 2 proposal, what, the working group has shared to us to date, if all of those changes are implemented and they're not necessarily like tweaked or changed in any way, like it is just something that like we're all going to have to like seriously take time to adjust to when they come into effect. Now, in estates, we don't typically proceed by commencing a statement of claims, or we're like typically not actually in the actions model. We typically go about our litigation by way of a notice of application, at which, and like that in itself has a supporting affidavit right at like the get-go, if not like additional corroborative affidavits as well from like the applicant's witnesses. And then after that, the respondents will file their responding affidavits and there's opportunity to reply afterwards. You could at that point agree or ask the court to sort of like take you out of this application process and put you back into like an actions model and go to discoveries next. Because the reason why we start as an application is because we like to get like preliminary production orders up front at the first appearance so that we can actually get at the deceased person's records. So and like, that really is like the biggest wrinkle, right? When it comes to like litigating a estate matter, it's like the primary person that the whole matter is about is no longer there. Whoever is the estate trustee has to step into that person's shoes, and they will often not actually have access to like the deceased person's documents. Um, Even access to like the lawyer's file, the lawyer that acted for the deceased. Court orders have to be made to waive like privilege and confidentiality. So like we do start very differently. But when you're starting to like talk about like even when you commence a statement of claim, you have to like include every single document at the same time. And I look at the actual timeline in which everything unfolds. It seems like we're given a little bit more time at the pleading stage where everything's sort of like 45 days apart. But by the time we get to the 6-month mark from when the person who is suing. So now I also don't know what people are going to be called. Are they like plaintiffs under an action or like applicants under an application? But whoever actually like commences the lawsuit, they have like within the first 6 months to also deliver all of their witness statements and the expert's report. And to me, that's quite scary because like yes, the person who has the claim, who's bringing the lawsuit, is in the driver's seat in terms of like when they actually like go to court, issue that initial process, and they can start the clock. But that really has to be weighed against like the limitations of time that this person has, right? Because we also have very strict limitation periods, right? There is a limitation period that affects us in the estates world under the Trustee Act. It is potentially 2 years from death, but it could actually even be potentially shorter than 2 years from death. And at which point, like, will that estate trustee have enough time to start something and have enough documentation in hand to even fulfill like that very first step of this upfront evidence model and also still be able to make their 6-month mark? Because ultimately the court is pushing everybody to marshal all of their evidence, have everything be available to either side of a proceeding within the first 12 months. So within the first 12 months, every side to a litigation is supposed to be able to see what each person's witnesses will have to say, sworn, each person's experts will have to say, all the documents that they're going to be relied on, and you're either going to settle or you're going to like take it to trial. That's a lot. That's very overwhelming to me. And in reading sort of like all the responses to the working group that I've seen from like the various organizations and just like talking to like friends and colleagues like informally, it's overwhelming to like everyone. Yeah, Mandana, like, what do you think? Like, as a new lawyer yourself, like, maybe it is good you're coming in so fresh that you didn't have time to form old habits. You don't have to like learn something new. This is just like part of the learning process for you. Whereas like for those of us who've litigated under like one model for some time, like now I have to change my habits, right? Like I now really have to learn something different. But how does this seem to you, as someone who had to like learn the rules in the first place?
Well, of course, until we like in practice we experience it, we cannot really comment on how it's going to be. I agree with all the points you raised about like our field of practice, that some of the suggestions are not really compatible with what we're doing. I've spoken with lawyers that are close to retiring. Actually, I was going to mention that with these reforms, they said we're gonna expedite our retiring process because we cannot we cannot adapt to this system. So I agree,
Yeah.
it's overwhelming. For me, like, although like I'm a junior lawyer, I don't have like much experience in the other model. It still seems a bit overwhelming considering the workload that the current cases that we have. If we want to add like new cases with the, I don't know how the transition procedure will be, but um, if we have to meet these strict timelines for new cases, along with, I don't know, with the transition from other older cases, it does seem overwhelming to me too. But with the use of AI and technology, there might be ways to overcome it. But as we have to wait and see how it's going to look like in practice.
Yeah, yeah. And I know that our existing system is far from perfect,
Sure.
right? Like justice delayed is justice denied. And post-pandemic, I think everyone is really truly feeling that more than ever. It's harder and harder to get court dates. Trials are being booked like many years out, and just getting records and being able to like get past that initial exchange of documents phase is often just like taking too long, right? It's just taking too long to get to the next step. So you can get to the next step and get to the next step and to be finally at that finish line where you're just really like burning people out because of time and how much money it takes to get through it in the first place, just from like the cost of just like constantly schedule a whole bunch of lawyers to make everybody's schedules work, and like adjournments, motions that get in the way. All of this is like a drag on every individual party's like pocket, as well as on the drag of like the judicial system overall and what the public has to like fund. So access to justice is really important. Timely justice is really important. I just, I'm not sure if the upfront evidence model, as much as it like, I think in a vacuum, in certain cases, it can be done. But I think there are just like maybe like certain practice areas like ours, like it is harder to think of maybe how this is going to unfold, especially if there is going to be less flexibility with the timing. Because, I could just think like you're never going to be ready for trial in a will challenge, and you may not be able to make the 6 month mark if you can't get that lawyer's file within the first 6 months. Like you have to get a court order to waive privilege and confidentiality. Law Pro has to be involved at first, and there's that first review from Law Pro. The drafting lawyer has to also like go through their office and give you the file, give the file to Law Pro, Law Pro's review, and then give it over. So like all of that takes time. And you know, of course, the goal has to be reducing costs, reducing time. I just don't know if this necessarily will enhance access to justice, or it will actually make this something that is maybe only available for those who can like afford it also up front, right? Because if you're front loading everything, everything is up front, and also all of the costs are up front. Like I don't know what this is going to do for those of us who like practice in like the civil litigation personal injury space where they do contingency agreements. Like this is a lot of work that these lawyers are going to have to fund. Um, and if not, then it's a lot of work for like that party to have to front and really just like put out of the pocket like from day one without really knowing like actually what you're even getting into. And a lot of stuff in estates, like we end up actually settling early. We settle early before we even get into like the examination stage often, because once you've sort of seen like the records that are related to the deceased and they're not there to be examined anyways, sometimes a lot of times like these files can settle early. But if you're going to be ready after 6 months, 12 months, is everybody going to go to trial? Maybe if you're so ready, you've seen it all, like you may be more inclined to just like spend like just a hump more and just roll the dice.
That's right.
Who knows? I don't know. No one knows what's going to happen.
Right.
Um, But it's been a really interesting thing to even reflect on, I think, like as a bar in terms of like how things are going, how things can be improved. Like I've never heard of anybody speak raise any issues with like the service changes. I think there are just some things that like we're all thinking like great idea. Why now? We just like, we could have used those changes as like email became like a really prevalent thing, the internet, etc., in like the last 10 years. But anyways, this has been a lengthy podcast as is. I really encourage everyone to actually like read the phase 2 paper from the working group from Meg, as well as all the responses. And as lawyers, we are never alone in our enterprise. There's always like someone nearby who's like going through the same struggles. And the more we talk about it, the more we share our thoughts with each other, the easier it is for us to like do our own work, as well as I think like the smoother the process it could be for everybody. I don't know. I like to be an optimistic person. So I think that concludes our podcast. Until next time, we want to thank you for listening. I'm Doreen So.
I'm Mandana Niknejad.
Should you have any questions, please email us at info@hullandhull.com or contact us through the contact page on the website. Thanks, Mandana. That was great.
Thank you, Doreen. Have a good day.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.